Hello and welcome back. In this installment, we are going to be discussing employee torts, classification of workers, negligent hiring and retention, the hiring process, employee discipline, termination, and severance. In this installment segment, we will be really focusing on a number of matters that we can draw from with our text, our handout materials, and our discussions that have been assigned previously. Let's start our conversation with employee torts. And we're going to divide employee torts into two columns. The first column will be for intentional torts, and the second column is unintentional torts. Now, a tort is a civil wrong other than for breach of contract for which compensation is the remedy. There may be an equivalent criminal action that is based on the same set or nucleus of facts that may also give rise to civil liability. So some of these various torts may also lend themselves to criminal culpability, but our focus is, of course, on the civil context, and in particular, the employment relationship. So you may be asking yourselves, what do these torts have to do with employment law? And in answering that question, query this. Do assaults take place within the workplace? Do batteries occur? Is there false imprisonment? Can there be defamation or invasion of privacy? Is there tortious interference or intentional infliction of mental distress that could occur in a workplace setting? Or, of course, we already know about retaliatory discharge, which is a tort as well. The answer then is yes. These torts, independent as they are, may also have application to a workplace or an employment setting. So too will the tort of negligence apply. Now, negligence is the unintentional conduct which gives rise to civil liability, where there is a duty which is owed. And we'll talk about that in just a moment. But let's begin our discussion with assault. Assault is the tort of intentionally causing a reasonable apprehension of imminent harmful or offensive contact. The threat to inflict injury places a person in fear of imminent bodily harm. Not harm that's been threatened that will occur next week or next month or next year, but momentarily into the future. Assault is often followed by the battery, but it is a separate independent tort. So you'll often hear assault and battery, but they are separate torts and must be examined with their separate applications in terms of the elements required. Battery is the offensive touching of another without consent or legal excuse resulting in harm. Harm may be manifested by physical injury or mental distress. Now, in your readings, there's going to be a case that we're going to discuss in a little while, and that case is the Livigny case, Bryant versus Livigny, and it's in your textbook. So think of these various torts as they may have some application to our studies within the textbook and otherwise. False imprisonment. It's an independent tort. It may also apply to a workplace setting. It occurs when there has been an intentional and unconsented restraint or confinement by one person of the physical liberty of another. False imprisonment can be accomplished by words alone or by physical actions or physical purposeful restraint. conscious awareness of the restraint and resulting harm are required. The tort of interference with prospective economic advantage may also apply in a workplace context. 4 elements are required. 1, there must be a reasonable expectation of entering into a valid business or, in the setting of an employment relationship, an employee-employer relationship. 2, the defendant's knowledge of that expectation is met. Now, that defendant could be, for instance, a former employer who is giving a negative or false reference involving a former employee to that former employee's prospective employer. You may recall that we discussed defamation a while back, and I mentioned that we're going to also talk about the tort of interference as that may apply to negative referencing. So if a former employer purposely, falsely interferes with the expectation of that former employee's new employment to cause harm, or in other words, keep the former employee from working in that new place of employment, given the false information that is provided in negative referencing, there could be a tortious interference claim. So going back to the elements, the 3rd element would be the purposeful interference by defendant, perhaps in the framework that I just mentioned, the former employer, that prevents the plaintiffs, and that could be a former employee seeking new employment with another organization, expectation from ripening into that employment or business relationship, and then damages to the plaintiff resulting from the interference. You may be thinking, what would be the damage? If that employee, for example, prospective employee in the context that I'm describing, doesn't get the job because of the so-called interference from the former employer, then there could be resulting damages, and that is the loss of wages or compensation that would have resulted but for the wrongful interference that prevented that person from becoming employed in the new setting. Tortious interference with contract under Illinois law requires the following elements to be established. 1 is the existence of a valid and enforceable contract between the plaintiff and another. 2, the defendant's awareness of the contractual relationship. 3, the defendant's intentional and unjustified inducement of a breach of the contract. And then 4, the subsequent breach by the other caused by the defendant's wrongful conduct. And of course, there must be damages or resulting injury. That would be a situation where there is an interference with a contract rather than an expectation, which was the previous tort that was just described. Let's discuss the tort of intentional infliction of emotional distress. With respect to this tort, you had a handout that I put together a few years back, a very detailed handout article that talks about the historical context and the background of this tort. The tort of intentional infliction of emotional distress really began to be recognized as a separate and distinct cause of action around 1930. And it developed over the years. It's been also known as the tort of outrage, which was first recognized in 1961 by the Illinois Supreme Court. But today, most often, it's referred to as the tort of infliction of emotional distress. And in other words, it involves injuries which are not physical, but are mental or emotional in nature. To prove the tort of intentional infliction of emotional distress, the plaintiff must prove the following. 1, the defendant's conduct was extreme and outrageous and intended to inflict emotional distress. Again, there has to be that intent aspect. This doesn't happen by accident or through negligence, but there is a conscious awareness to inflict a level of extreme and outrageous conduct and resulting stress that's experienced by the employee. There had to have been some form of knowledge, or at least a high probability, that such conduct would inflict indeed severe emotional distress. And lastly, the defendant's conduct did cause severe emotional distress. So I'm going to ask you, as we go through these slides, to work through, if you haven't already, the handout, which is entitled The Tort of Intentional Infliction of Emotional Distress in the Context of Employment. Let's look at some of these separate components. Extreme and outrageous behavior. Liability will not apply to mere insults, indignities, threats, petty oppressions, or other trivialities. In other words, the conduct really has to be extreme and outrageous. And there's cases within this article or presentation of this format that reflect how terrible some of these facts are that would indeed suggest that the conduct is outrageous and extreme. There has to be some objective, reprehensible behavior as well. Recovery has been limited to cases in which the employer's conduct has truly been egregious. And there's some cases that I've cited that will give examples. I'm not going to go through those cases here in our discussion right now, but I do ask you to turn to those cases, in particular the case involving a situation that went to the appellate court in Illinois, known as the Pavlon versus Cafferly case. Threats of physical abuse have also been the source of recognizing an intentional infliction of emotional distress tort. Threats of coercion and retaliation as well have formed the basis of recognition of this particular tort in Illinois. Where there has been abusive, disparate treatment. Now we know what the term disparate means. Abusive, disparate treatment can also lead to the separate common law tort of intentional infliction of emotional distress. And by the way, all these torts that we're describing and focusing on represent common law sources of employment law. They're not statutory in nature, but they have their origin in judicial-made decisions, which would be case-by-case matters, which are litigated and decided upon by courts. When we look at this particular area of law, the degree of power or the authoritative position over the plaintiff is often examined. In some situations, examples of non-responsive employee or employer awareness of abusive supervisors is also a factor. And again, that's covered in this handout. Uncorrected and continued hostile work environment situations may also lend themselves to the possibility that these types of torts could be initiated depending upon, of course, the conduct. Let's talk about intentional infliction of mental distress. For damages, I put on the top punitive damages to generate discussion because in this particular arena in Illinois, punitive damages are disallowed. In some other jurisdictions under the common law heritage of those courts, there could be a recognition of punitive damages. But in Illinois, punitive damages are not available as a source where there has been intentional infliction of emotional distress or mental distress that's been proven. Compensatory damages would be available. Compensatory damages is a term that we know already. Can be the pain and suffering, the distress, the embarrassment. Lots of different elements can relate to compensatory damages for recovery. Courts in Illinois have said that no expert evidence is required to prove intentional infliction of emotional distress as a tort. In other words, you don't have to have a psychologist or some healthcare professional that would serve as an expert witness. Also, what's important is that no physical injury is required either. In some jurisdictions, and historically, a physical response to the conduct, which is egregious and outrageous, is necessary for there to be liability. In our jurisdiction, that physical injury or physical repercussion is not necessary. And courts will also allow, as a measure of loss, economic damages when there has been liability established for this particular tort. Next, let's turn to negligence. Negligence. Now, negligence is where there is a duty imposed to make sure that there is no harm or injury that occurs when there is a foreseeability aspect. And when I talk about foreseeability, what would a reasonable employer foresee could occur based on actions that may have applied in the past or conduct applied in the past that they were aware of. And I turn your attention to the case in our textbook that Professor Twomey has selected for our reading. And the case is Bryant versus Lavigne. And there's two very important theories or concepts which are brought out in this case. Now, I've also mentioned in our discussions that this particular textbook is national in scope. In other words, it's used throughout the United States by college students and law school students for study. And I've mentioned that in many of these chapters, which we've covered already, you'll note how often Illinois cases are cited. Well, this particular case that I'm going to talk about in just a moment is from 1994, is still good law today, 24, 25 years later, and it's cited around the country even still as a source of authority. So let's talk about two separate theories that apply when there is negligence within a workplace setting. And the theory we're going to begin with is respondeat superior. Under this common law rule, the employer is liable only for those torts committed within the scope of employment and in furtherance of the employer's interest. So when we discuss scope of employment, think about what's taking place within the aspect of that particular employee's situation. And if there is an aspect within the so-called scope of employment, then is that aspect or conduct in furtherance of the employer's interest? The next theory is negligence. A negligence theory. Negligent hiring, supervision, and retention theories have been used to impose liability where an employee commits an intentional tort, but, note this, outside the scope of employment against some third party, against a customer, for example, a member of the general public, or even co-employees or others. The theory behind that action is the employer knew or should have known. In other words, they had the foreseeable opportunity to understand that harm could occur. So the theory is the employer knew or should have known that the employee had a propensity to commit harm, but was negligent in preventing such harm from occurring. To establish negligent hiring, for example, the plaintiff must prove that the employer knew or should have known that the person hired had a particular unfitness for the job that would create a foreseeable danger to others. Here again, I use the term foreseeability or foreseeable. Does the employer, for example, or does an organization have the opportunity to foresee that there could be a harmful situation occurring, even though it would be in the future, based on something that's occurred in the past? The key point also would be the particular unfitness, the propensity to commit the harm, was the proximate cause of the plaintiff's injury. So think of these aspects that we're looking at now within the framework of what occurred in the Bryant versus Lavigne case. Now, I've also, again, had a handout for you, and I hope you've looked at it. It's entitled Pre-Hiring, and I'm going to ask you to turn to that in just a moment, or if you haven't read it already, please do so. And again, this lecture might have a little bit more effect or application if you've already gone through that, which hopefully you may have. If you haven't already, please do so. Negligent hiring decisions by courts involve an analysis of a particular job and the potential risks. I'm going to quote from a case from a matter that was adjudicated in 1979, the Easley versus Apollo Detective Agency case. And this is where the court says that, moreover, it has been held that in the selection of an agent, an employer will be held to the exercise of care reasonably commensurate with the perils and hazards likely to be encountered in the performance of that agent's duties. That is, such care as a reasonably prudent person would exercise in view of the consequences that reasonably would be expected to result if an incompetent, careless, or reckless agent was employed for that particular duty. In the Easley Easley case, the appellate court upheld a trial court's decision finding a security guard company liable for negligence in hiring an armed security guard who used his employer-issued key to gain entrance to an apartment and attempted to accost the occupant. The company did not check the security guard's prior addresses, personal references, or criminal history before hiring that individual. So in the section within the handout, you'll see that there is a chapter or a heading called Background Checks and Checking References. So please examine that as we go through this material as well. Again, for negligent hiring, most situations involve an employee injuring someone, which could have been prevented if the employer reviewed the background of the employee prior to hiring. Arrest and conviction records are public records. However, Illinois law bars employers and prospective employers from getting access to arrest records that do not lead to convictions. In Illinois, we have the Illinois Human Rights Act, which we've discussed previously, and within that act is a prohibition against discriminating toward or against individuals who are arrested. Remember, there's a presumption of innocence. Simply because one is arrested does not mean that one is guilty of that charge. An arrest is just an arrest and not a conviction. Background checks are best conducted after an offer of employment has been extended, conditional upon such employer investigation, and of course with the consent of the employee. I cannot emphasize that more so, that all of these inquiries are best conducted upon or after an offer of employment has been extended, which is conditional upon learning more information that would allow that employer to feel comfortable in moving forward and having that employee-employer relationship commence. So finally, let's talk about the Bryant versus Lavigne case. It involved the theories, as mentioned earlier, respondeat superior, as well as negligence, in the context of negligent retention liability. The jury, and this was a case that went to trial, and there was a jury, concluded that the actions of Lavigny in attacking Ferris, and when you read the case, if you haven't already, please do so. This will make more sense if you've already read this. But the jury concluded that Lavigny and his actions against Ferris were committed within the constraints of the authorized time and location of his employment. What does that mean? That means that there was activity, conduct, actions that occurred during the scope of his employment, which allowed then the jury to conclude that the employer was responsible. So, in this particular case, there was a battery, and the battery occurred within the course and scope of Lavigny's employment, ultimately allowing the jury to decide that the employer was responsible for the damages. The appellate court sustained the jury verdict, in other words, upheld the decision made by the jury, and the trial court's decision with respect to evidentiary issues and findings, ultimately concluding that negligent retention and respondeat superior liability existed. When you read this case, please also consider the dissenting opinion by Justice Welch, which concerns imposing on the employer an unreasonable burden to analyze criminal records of its employees. A dissenting opinion is another point of view that the minority of the appellate court or Supreme Court, for example, would hold, or could be just one judge in a panel of three, that the majority doesn't. In other words, the minority opinion differs from the ruling and rationale for that ruling by the majority of the justices. Sometimes, over a period of time, depending upon how the courts change, a dissenting opinion may be recognized and will evolve into the majority view of the court. So dissenting opinions are an opportunity by a justice to offer their point of view in terms of the rationale, reasoning, and outcome of a particular case that differs from that used by the majority of the justices. Let's talk about damages. If there's liability established, there can be damages. What are the damages? Compensatory damages. And we know from our discussions previously and our study what comprises compensatory damages. Economic damages are available. Back pay and front pay. And we, of course, know what that can include as well. And punitive damages. Punitive damages, as we have said before, are designed to punish and deter conduct of the sort from occurring again by example, so that others don't follow that same behavior, because if so, there could be a consequence economically aside from damages to compensate. So punitive damages are available in most tort cases, especially where there is an intentional aspect, but again, in both of these examples, there's negligence. So ask yourselves, why would there be punitive damages allowed in the context of a negligence claim? The answer to that may be based on the level of negligence and the foreseeability aspects of how that conduct could have been prevented based on reasonable actions taken to address what's occurred in the past. Again, this concept of foreseeability, and if that level of foreseeability was ignored, resulting in harm that later occurred. Can that give rise to the imposition of punitive damages? Well, we saw in the case of Lavigny that yes, it did. So please examine that case carefully. It has a lot of application for our understanding and our study. I included in this slide discussion the exclusivity of workers' compensation laws. In Illinois, we have the Illinois Workers' Compensation Act, which is an employee's exclusive remedy for accidental injuries arising during the course of employment. Courts have occasionally held that an injury which was intentionally inflicted on an employee by another employee is considered accidental for purposes of the Illinois Workers' Compensation Act if it was unexpected and unforeseeable from the injured employee's point of view. When the person who intentionally injures that employee is not the employer in person, or a person who is realistically the alter ego of sorts of the corporation, such as a foreman or a supervisor or manager, both the legal and the moral reasons for permitting a common law lawsuit against the employer go away, they collapse. So courts have ruled that the exclusivity provision of the Illinois Workers' Compensation Act do not apply if the injuries were intentionally inflicted by the employer or by its alter ego, or if the injurious actions were commanded or expressly authorized by the employer. And there's some further reference to this aspect or this particular rule in the handout involving intentional infliction of emotional distress. I thought it would be interesting if you had that background understanding. Many states will use or recognize the exclusivity of workers' compensation laws as a legal defense against these intentional torts that are sometimes raised in the employment context. Let's next talk about classification of employees. That's a big topic for our discussion. It's covered in our textbook, and you should have a working understanding of what all this means in terms of classification of employees as we go through this. Please turn to the section in your textbook that Professor Tomey has outlined. It may be listed in your particular textbook under figure 16.1. It's questions for ascertaining independent contractor or employee status. It's an excellent chart that really, I think, helps students understand the differences and how the facts will determine the distinction between an independent contractor and an employee. Now, proper classification of employees is essential to avoid liability for a variety of reasons, claims, and of course the imposition of taxes, fines, or related sanctions. If the individual is an independent contractor who has earned more than $600, the employer must supply an IRS Form 1099 to each contractor stating the amount of money paid the contractor during the year. If the employer hires an employee, and then the employer must have an employer identification number, pay state and federal employment taxes, provide workers' compensation insurance, withhold payroll taxes, both state and federal, and submit payroll returns monthly and quarterly, and pay Social Security taxes equal to the amount withheld and paid by the employee. Those benefits are traditionally not available to an independent contractor. So we need to understand the differences between who is and who is not an independent contractor and really appears more as an employee. In the case of Nationwide Mutual Insurance Company versus Darden, it's a U.S. Supreme Court case from 1992. The Supreme Court set forth factors to be considered in determining whether temporary workers are common law employees for the company for which they perform services. And the factors are recruitment, training, duration, right to assign additional work, and control over the relationship between workers and the employment agency. As Professor Twomey points out, the degree of control the employer exercises over the individual's work is pivotal in making the proper determination. And again, please let's examine figure 16.1. It may be 6.1 in some of your textbooks, but it relates to ascertaining independent contractor or employee status. Let's examine a few of these questions. Does the employer provide tools, supplies, and equipment? Would an independent contractor typically do that? Well, the answer is probably yes. Would the employer provide that equipment for an individual that doesn't have same? If that's the situation, then there's probably going to be more of an employer-employee relationship. Look at number 9. Does the individual work as a professional or a skilled technician? Can that be indicative of an independent contractor or an employee relationship distinction? You have to examine the facts. Think of who is brought in to do what particular job and what their expertise is. No one of these factors will determine whether there is an independent contractor or employee relationship in and of themselves. Often there has to be a collective analysis of a variety of factors that go into the distinction between who is and who is not an independent contractor or an employee. Before we get to the hiring process, I want to just spend another moment on this chart that Professor Twomey has supplied. And one of them is, let's look at number 5. Does the individual have a continuing relationship with the employer and maintain regular hours of work at the employer's business? If there is continuity and an expectation that the work is going to continue, that is synonymous, is it not, with the employment at will doctrine. An employee is working at their discretionary will, at the discretionary will of the employer. Compare that situation to an individual who is hired for a particular event or term or duration of time. That can still be a situation where there is an employment relationship, but it might also suggest that that relationship could be more akin to an independent contractor relationship. So again, no one of these factors is outcome determinative. You have to look at the composite and make a distinction using the analysis that we have to work with. And fascinating area. It's an area where there's also lots of litigation, lots of information in writings and articles that you might want to inquire into or look further on the internet or with some law journals. Okay, next let's look at the hiring process. As we've learned, various employment laws apply to not only employment relationships, but previous to that relationship occurring. Again, referencing a handout that you've been provided. The handout relates to a section that I've identified as pre-employment interviewing. And take a look at that. The interviewing process can be scrutinized for potential discrimination claims. There's generally always an opportunity to solicit business-related necessary information without violating the law or exposing the business to potential liability. Please reference the pre-employment inquiry checklist of illegal and legal hiring inquiries found within the course materials provided. Now, please note that this checklist is not exhaustive and does not relate to every situation. And by the way, these questions, these different divisions between lawful pre-employment questions and pre-employment questions to avoid. And the subject matters, I've not made these up. These are all sourced from various regulations, court decisions, and other material that I think you'll find very interesting as you read through this as to what kinds of lawful pre-employment questions may be considered and asked versus pre-employment questions to avoid. And you may also think, well, why are we discussing this now toward the end of our employment law course study? If you think about that inquiry, if we would have started with this section, would you have had the depth of understanding and knowledge that you've accumulated through our studies together to be in a position to really understand and analyze these points? So in my view, this pre-employment interview and the pre-employment considerations as we look at the entire employment spectrum, which we discussed early in the course, best fits after you've achieved a level of understanding as to what the potential liability is and the source of that potential liability in terms of the regulations, both by statutory and common law applications. Let's next turn to the topic of employee discipline. And again, we're looking at this aspect of our study toward the end of our course, having drawn from the experience and our understanding of, and readings that we've already done, from case law to the text to these handouts, so that we can be in a position to then evaluate what kind of employee discipline may be appropriate and what are the risks. A considered, consistent discipline policy, documented and communicated to employees. And think about that. Documented and communicated to employees. In other words, giving the employee a level of understanding as to what the expectations are. Permits the employer to take measures toward corrected, harmful, or counterproductive behavior, while at the same time reducing the likelihood of generating a charge of discrimination. Documentation of the problem or corrective measures taken are powerful tools in the defense of claims of illegal discrimination, as well as supporting a misconduct defense to an unemployment compensation claim. Termination. There's a whole handout section of termination that's also included in your course material. If you haven't received that when you are listening to this lecture, it should be posted in short order, but there's a section involving termination. A termination may be voluntary or involuntary. By this, it's meant whether the employee has chosen to quit his or her employment or has been fired. Employment is generally, as we've discussed, at will. If, however, an employee is subject to an employment agreement, a collective bargaining agreement, or is a public employee, special rules will apply. The provisions of the employment agreement or collective bargaining agreement must be followed in terminating such individual's employment. Also, if the company has a handbook or guidelines for termination, as we've talked about earlier in this course, or has informally followed certain policies in termination, whether they're written, published, or not, in the past. In other words, where there are practices. Those policies and practices must be considered with respect to the decision to terminate. The termination should not be for a reason which would give rise to a claim against the employer. For example, discrimination, retaliation, etc. Severance agreements. Our course study also involves some description of or understanding of severance agreements. Interesting topic because unless required by contract, a severance plan or agreement otherwise, severance is not mandated by law. Severance historically has been considered as a gratuity. The historical purpose or application of severance is to allow a separated or terminated employee certain transition money or consideration to bridge the period between the job loss and the replacement employment opportunity that hopefully would arise. State unemployment compensation benefits also provide supplemental income for such transition period between employment. And we've studied, of course, unemployment compensation areas. Employers will often treat severance as contract consideration to bind the employee's promise in return for the release of claims, waiver of rights, and other conditions. In other words, the employer will offer severance as legal consideration to bind the employee's promise not to sue, to release claims, to waive rights, and other conditions. Now, we've talked about already in this course the Older Worker Benefit Protection Act of 1990. That too involves severance agreements, and I think I mentioned in that series lecture that we'd be talking about severance agreements in more detail later on. Well, we're talking about severance agreements now in more detail here and now. So you might want to ask, why would an employer want to offer severance without any type of return aspect or consideration? Well, historically, that's what happened. Severance was offered as a bridge, as temporary transition money to allow that employee something to fall back on during their period of unemployment until that next opportunity arises. As employment law has developed and our society has become more litigious, if you will, employers will often use severance as a so-called vehicle to avoid the potentiality of possible litigation or claims arising by that employee resulting from termination into the future. Courts examine these severance agreements very carefully. They look to whether or not there's adequate consideration and what the circumstances are. And of course, there's some rules that we know that have to be followed, and a good example of that would be the OWBPA, the Older Worker Benefit Protection Act. So we've covered employee torts. We've covered a lot of different informational points in this segment, including pre-hiring considerations, terminations, and a lot in between. So we've got more to go in the course, but I do want to make sure that you have a good understanding, especially involving these employee torts. Thank you.